Okay, I think we're probably ready to start. Hi, everyone. I'm Valerie Vanneman. I am one of the attorneys at the Newman Aronson Vanneman LLP law firm. We are a law firm that's been doing this sort of work since the late 70s and early 1980s. And we have a number of attorneys in our office, all of whom, well, almost everyone does special education law and has been doing so for some time. We are delighted to have you all join us. We know that this is a difficult time, and we want to try and talk about a number of things. But before we do that, I have just a couple of housekeeping things. One, you're not going to be able to participate in this session orally. If you have a question, please put it into the question and answer or to the chat room. Two, to hear the webinar in Spanish, access the Zoom controls by moving your cursor over the Zoom screen and select the interpretation. Then select Spanish, which is the only language tonight in which we are doing interpretation. You can also find a call-in number in the chat area if you want to call in instead of be on by internet. We encourage you to submit your questions during today's webinar. Do use the question and answer feature, please, on your Zoom controls. Again, what you do is move your cursor over the bar at the bottom and select the Q&A, ask your question, and the question will then allow us to know that's a question waiting that we're going to try and answer as we go along. We will attempt to get to questions a lot at the end of the evening as we move along, because we think some of the things we have to say as we go along may answer some of the questions. And if they don't, of course, we'll pick them up as we go along. That's our housekeeping. Let me turn and introduce you to the people you'll be hearing from tonight. Jody Binder is an attorney who has been working with me for many, many years. Quite an experienced special education attorney, and we're delighted that she's able to participate tonight. Dina Kaplan joined us not long ago from her previous prior practice, is an extremely experienced special education attorney, and has her own personal experiences with special education and brings a wealth of empathy and understanding to what's happening. Brian Nguyen started soon out of law school. Actually, I think he started while he was in law school with us. Has worked consistently in the area of special education when he's not off being a filmmaker. And again, brings a wealth of experience to this. And then our last speaker this evening, Sophia Blissiotis, has also been doing special education for a number of years and brings a wealth of experience to us. What we're going to do tonight is try and cover a series of topics that are current. And if I could have the slide showing the series of topics, that would be great. We are going to be looking at topics that include, next screen, please. Can we get there? I'm Valerie, there they are. Tonight's discussion is going to look at a couple of things, well, more than a couple. We're going to look at the federal law that remains in place, because I don't know about all of you out there who have some experience in this area of law, and even for those of you who are new, what a pandemic has brought out is a return to the law books. And a return to the law books is always a great thing. It allows us to, in fact, look at a variety of topics that we may think we really knew, and we find out they're even richer than we thought. We're going to look at some state law and problems. What's been happening in California through all of this? Why are you having some of the problems you are? Assessments. Many, many, many of you have questions and concerns about assessments. We're going to talk about why you have those concerns and what might possibly be done about it. We're going to talk about IEPs. We're going to talk about due process remaining in effect. We're going to spend a little bit of time on remote learning challenges. And then we're going to spend some time talking about possible courses of action for parents. and then hopefully get to the questions and answers. We will get to the questions and answers. The PowerPoint presentation that you will see throughout this evening will be available on the website for Newman Aronson Vanneman LLP, as will a recording. And we will be able for you to get those, but they probably won't be up until tomorrow. Indeed, that's not a probably. They won't be up until tomorrow. But as of tomorrow, you'll be able to access them. We're going to begin talking first about some of the basics. Many of you will think you've heard all this before and you know it all, but as you've all found out in your own lives and own experiences, in a pandemic, everything has a twist. And so Dina Kaplan is going to take over and talk a little bit about the federal law, where we are with regard to it, and the twist. Dina, I'm going to turn it over to you.
Thank you, Valerie. For those of you who don't know me, I have a 26-year-old son who's got multiple physical, developmental, and mental health challenges and has experienced every service known to man. And I had lots of problems while he was in school, and even more problems now that he's out of school. When we were looking at putting this together, I realized that the situation was changing so rapidly that I felt like I was getting whiplash. Every minute there would be something else coming across my desk. And so what we're going to do tonight is give you up-to-the-minute information, but please check our website regularly and sign up for our newsletters to keep yourselves informed of what's happening. Like I said, it's happening really quickly. Next slide, please. So one thing that I went back and looked at, because I haven't looked at it in a little while, is the purpose of the Individuals with Disabilities Education Act and IDEA that controls all special education from the federal level. And I looked at the purpose, and I want to read it because it's important. The purpose is to ensure that all children with disabilities have available to them a free, appropriate public education, which is our standard FAPE, that emphasizes special education related services designed to meet their unique needs and prepare them for, this is a key, further education, employment, and independent living, and to ensure that the rights of children and their parents are protected. I think that part that says further education, employment, and independent living is very important when you consider the whole gamut of goals, objectives, and what you want for your child in the future. And so keep in mind that we're not just looking at academics, we're looking at developmental, we're looking at physical needs and how the child's needs are going to be met, both from a physical standpoint, educational standpoint, developmental standpoint, and how we are going to prepare the child to be independent. So the Law School 101 says that the federal law controls over state law. So federal law is the key. State law can provide more than the federal law, but it cannot provide less than the federal law. And so that's also very important. Now, something to keep in mind also is that nothing in the IDEA has been waived as of this moment. So we are still in full force and effect with IDEA. And for those of you who aren't familiar with the new case that came down in March of 2017, the Andrew F. case, that case basically said it upped the standard. Now, for many, many, many years, the standard was what is known as the Rowley case and the some educational benefit standard, which everybody was saying is a very low standard, and obviously it is a very low standard. And so what Andrew F. did is said that a child an IEP must reasonably calculated to enable the child to make progress appropriate in light of the child's circumstances, and every child should have the chance to meet challenging objectives. So the question is, does that up the standard? And for the most part, it definitely does. But I'm going to jump now to assessments because I think that this is extremely important. When you're looking at the child's circumstances, you need to have accurate assessments that show what your child's circumstances are, what your child is able to do, what you want your child to be able to do. And in order to develop goals, you need to know what their present levels of performance are. So assessments are crucial for obtaining that information, determining your child's present levels of performance and their eligibility for special education. And we went back to look at the timeline. So initial assessments under IDEA should be completed and an IEP meeting held within 60 calendar days of the date the parents consent. There's no timeline, though, in IDEA for reassessments, except it says not more than one time per year and required every 3 years, which we call the triennial reevaluation. California law provides a 60-day timeline for both initial assessments and reevaluations. My colleague Jody Binder is going to talk more about assessments, but I want to look at one other point in IDEA that says all areas of suspected disability. A child should be assessed in all areas of suspected disability, and the tools that are used for the assessment need to be appropriate to yield accurate information regarding all of the child's educational, developmental, and functional needs. And that's really important because one of my pet peeves as a parent of a lower functioning nonverbal child is that he was never accurately assessed. The standardized assessments are not meant for children like my son and some children that I represent. And so far, I haven't been able to find real accurate assessments to do that. So I think that I have put my feelers out to people who are experts in the area of assessments to give me some insight on better ways to assess kids who are nonverbal and who have a lot of challenges that aren't able to access the standardized assessments. So I think that's very important. And Jody also will probably discuss independent evaluations. Next slide, please. So we're still talking about IDEA 101 and IEPs. And for those of you who might not know, the eligibility categories are, and so let me back up a second. The assessments will determine present levels of performance and then eligibility. And so we're looking at mental retardation, although now it's called intellectual disability, hearing impairments, speech or language impairment, visual impairments, emotional disturbance, orthopedic impairments, autism, traumatic brain injury, other health impairment, which includes ADHD, anxiety, psychological problems, and specific learning disability. So those are the categories of eligibility, but you have to keep in mind that in order to be eligible, the child needs to be in need of special education and related services in order to benefit from their educational program. So if a child is autistic but doesn't really need any assistance in school, then they're not going to qualify for special education. But if a child has a diagnosed disability eligibility and the assessment determines that they are in need of special education and related services, then the child will be found eligible. And the content of the IEP, again, is really important. It has to have a statement of present levels of performance based on what the assessments say, and hopefully accurate assessments say what the child's present levels of performance are. A development of measurable annual goals and short-term objectives based on what your child's present levels of performance are, what special education and related services and supplementary aids and services are necessary in order to enable the child to meet the goals and be involved in general education curriculum to the greatest extent possible, and what necessary accommodations and modifications. And the IEP team is required to state if the child is not going to be in special education 100% of the time, in general education 100% of the time, what is the reason why, and how much of the child's time will be spent in general education. So that's an important thing. The related services in California are called DIS, or Designated Instructional Services, and include such things as speech therapy, occupational therapy, and physical therapy. One other little sentence that I find very interesting is that it says that the IEPs must consider the assistive technology needs of every student. And so many times I see an IEP, I pick it up and I look at it and it says assistive technology no, and I ask the family, did they discuss at the IEP team meeting that your child's assistive technology needs? And they said no. And so a lot of times the IEP team makes that decision without consulting the parents. We are now finding out how important assistive technology is. And so it's very important for parents to bring up assistive technology needs. And if you think that your child needs some kind of assistive technology, you can ask for an assistive technology assessment. Also, if your child needs some kind of augmentative or alternative communication, you can ask for that kind of assessment as well. Okay. Dispute resolution basically is pretty simple. We can do informal dispute resolution process. Los Angeles Unified School District has their own, what we call IDR process. The smaller districts usually can be, an informal dispute resolution can be done by setting up a meeting with the special ed director. Oftentimes that will help to move a dispute along. When there's no way to resolve those disputes informally, then the next step is formal due process. And that's what our firm does. We represent children in formal due process proceedings that are filed with the Office of Administrative Hearings in Sacramento. And once you file for formal due process, which is filed, we file a complaint, which indicates what our issues are, what the facts surrounding the case are, and what our proposed resolutions are. And then three things can happen. The first thing is a resolution session, which is an informal resolution session within the first 15 days of filing a complaint. And then oftentimes we don't participate in resolution sessions because there's no means for reimbursement for attorney fees for resolution session attendance by attorneys. So, and oftentimes resolution sessions don't really resolve the case. We most often go to mediation. Now, sometimes resolution sessions will resolve the case if we get a call from the attorney representing the district, and this is not in LA Unified because that's not their process, but in the smaller districts, oftentimes we'll get a call and they'll say, do you want to discuss settlement and through a resolution or an informal resolution? And we say yes. The next step, if the case is not resolved informally, is mediation. And that is a process by which well, now it's done virtually. We used to go down to district offices, and a judge from the Office of Administrative Hearings was sent to help us mediate the dispute. Now it's all done online, and it's an interesting process. Most of our cases are resolved in mediation. And then if they're not resolved in mediation, then the next step is to go to a hearing. And Valerie can tell you from firsthand experience that virtual hearings are not so much fun. And they are just like a trial. You have to have evidence, you have to have experts, you present your case, you cross-examine witnesses, you present your witnesses, and then you submit your closing argument. And then you leave it up to a judge to make the decision as to whether or not you are going to be the prevailing party and what your remedies are going to be. Next slide. So I want to talk about the elements of concern during COVID-19 and the things that we've seen so far and what we're seeing that's changing, which I'm going to get to toward the end. But probably many of you are aware that in March of this year, the federal government came out with a question and answer document on providing services to children with disabilities during the COVID-19. And what it said was, because initially when everything shut down, districts were scrambling, they didn't know what to do. And what this said was that if a district continues to provide educational opportunities for general education students, it also has to provide the same opportunities for children with special needs and equal access to the provision of equal access to education, and to ensure that their FAPE, their free appropriate public education, was being provided. What that looks like virtually, as all you parents out there are finding out, is sometimes really good for kids, sometimes not so much. So it also the Q&A also talked about developing a distance learning plan. That could be something that is put in an amendment to an IEP, or it can be a separate document. It's meant to be a temporary plan. So temporary, hopefully this virus will get somehow controlled, and somehow we'll find a vaccine, and the schools will reopen, at which point obviously the distance learning plan will no longer be in effect. So I think it's important, if there's an amendment to the IEP, to add a distance learning plan, which I'm seeing some districts do. You need to make sure it's very clear that it's only during the time that the schools are physically shut down, and read what's written very carefully. And so the other thing that was important here is that it said that if a child's not able to benefit from special education and related services virtually, or in any other manner that's being provided during the shutdown, then compensatory educational services could be considered on a case-by-case basis. So in this area of the law, for those of you who don't know, there's no money damages. The damages per se are compensatory educational services to make up for the time that your child wasn't provided with an appropriate education. And you're going to hear this repeated several times tonight. Something that's very, very, very important is to document what's happening. We have a form on our website that you can access, that you can print out and use to document. But we need to know, and it's going to be important for any case that seeks compensatory educational services, we need to know what's being provided, what is said in the IEP. For example, if the IEP provides for resource support services 3 hours a week and your child's getting 30 minutes a week, that's obviously a big difference. You need to document that. If your child's able to benefit from it, obviously you want to document that. But if your child's not able to benefit from it, you definitely want to document that. I've had so many parents come to me and say, my child, I set up the iPad, we get on the Zoom meeting, the teacher starts talking, and my child runs the other way, and I'm carrying the iPad and running around the room trying to get my child to pay attention. Obviously, the child's not benefiting from that program. Something that I was thinking about today is that we're all very, very, very overwhelmed by what's going on, and the stress of being at home and trying to work and trying to be teachers and trying to take care of our family. And so documenting is probably the last thing you want to do. But one thing I was thinking about is there's an app that I use frequently, and there's probably other ones out there, but the one that I use is called Otter Voice Meeting Notes, OTTER, like the animal otter. And what it does is it allows you to record something that, you can speak into it, record what's going on, and it transcribes it. So there you have your documentation. That app gives you 600 minutes a month for free. There may be other apps that give you more for free, but they're not that expensive on a monthly basis. And if you're really overwhelmed, you can just talk into your phone, and then you can download it and print it out. And you have to play with some of the language and the typos, but for the most part, it's a pretty good way to document what's happening. And we're going to need that information if we are going to go ahead and file for due process to get compensatory services. Okay, the next slide, please. So the thing that was great about what the Secretary of Education, Betsy DeVos, said on April 27th was that she declined to grant any waivers of any requirements of the IDEA. And this quote was great. While the department has provided extensive flexibility to help schools transition, there's no reason for Congress to waive any provision designed to keep students learning. With ingenuity, innovation, and grit, I know this nation's educators and schools can continue to faithfully educate every one of its students. So that was great for us. So just to be clear, the federal law remains in effect. The federal law controls over state law. And my colleague Jody is going to talk to you about what's going on in the state, and as are Sophia and Brian. And arguably, some of the things that are going on in the state are less than what the federal law provides. So it will be interesting to see how things evolve over the next several months. And so the question is, what continues? Basically, everything continues. IEPs are continuing. They should be held. An IEP should be in place at the start of every school year. And you know, I'm getting a lot of calls from families saying, oh, my IEP was due in March or April or June and it wasn't held, and so now my child doesn't have a placement. Or, you know, there's no IEP in place with present levels. I'm seeing some IEPs that say the present levels are based on what we knew before COVID shut down, since we haven't done any assessments and we don't know what the child's currently doing, which is kind of interesting, somewhat problematic. So I think it's important to document that. The DIS services must continue. Certain circumstances, they can be provided in person, and that's something that we're going to discuss a little bit later because we just got some new information actually today. So assessments need to continue. Again, that's something that can be done virtually. In some cases, some assessments need to be done in person. What that's going to look like, we're still trying to figure out. And I think Jody will talk a little bit more about that. And due process is continuing. We are continuing to seek compensatory educational services for loss of educational opportunities. I think to keep in mind, however, when would be the best time to file for due process. And there's a 2-year statute of limitations, so you have 2 years to file from the date you knew or should have known about the issue causing the lack of educational progress to file for due process. So you might want to wait until sort of toward the middle of this school year or after the first of the calendar year to see how your child's doing, to see if any in-person services have been provided, to see if, you know, just basically regroup and decide if your child's benefiting, if their child's not benefiting, what could be done, what your child needs, and what kind of compensatory services would help reduce the loss of educational benefit. However, you also have to keep in mind that, and one thing that we have been doing is getting a long period of time in order to access the compensatory services. So for example, if we get compensatory speech services, a block of hours for compensatory speech services, we ask in our settlement agreement to give the family 2 years to use those, to access those services, so that if the family wants to wait until they can take their child in a face-to-face situation in person with the speech therapist, they have the time to do that. So those are some of the things to keep in mind with regard to due process. I'm going to turn it over to Jody. And
Dina, 1 minute.
Go
Dina,
ahead.
before you do that, could you repeat again? There are several people who've asked for the information again on the app Otter, or the app for transcribing that you mentioned.
Yes, and I forgot to write it down. It's Otter, O-T-T-E-R, Voice, V-O-I-C-E, Meeting Notes. And it's on the app, I don't know about Android. I think that you could do it on Android, but I know you could do it on the App Store. And there are several other apps. I went in there today to take a look. But I love these apps because, you know, we use them for IEP meetings, for mediation, or not mediation, for due process hearings. where we have to record and listen to what's going on, and it gives us a transcription. So, any other
And the
questions?
second question, yes, and the second thing before you go, Dina, just to a couple of housekeeping things again. I know I have some people raising hands for questions. We'd really appreciate it if you'd put it in the question and answer button that's at the bottom. And then secondly, Dina, could you just talk for a few minutes, take a brief second or two, and discuss what the phrase compensatory education means?
Okay, I could do that. So compensatory educational services will, whoops, I don't know what happened there. So compensatory educational services are what we provide to children who have sustained a loss of educational benefit. What that looks like for each child is going to be different. It's going to be based on what the child's needs are, what the child wasn't receiving, and what the child needs in order to make up for their loss. For example, if you have a child that's getting on his IEP, supposed to be getting speech therapy, occupational therapy, and resource support, I'm just throwing that out there, and they haven't gotten any of that for a period of time, then we would look at compensatory educational services. What the law says is that you're not entitled to hour for hour, minute for minute for compensatory, but you're entitled to compensatory services to essentially make up for, which I don't think they ever 100% make up for, but to help bridge the gap in terms of what your child lost and to try to get your child caught up. Is that, did you have something
That's
to add?
great, thank you. No, let's move on to Jody.
Okay, thank you.
Hi, I'm Jody Binder, and some would say I grew up at Newman Aronson Bannerman because I've been here since I was in college, before Valerie convinced me to go to law school, and have been here my entire career with the exception of a few years. So with that, let's talk about assessments. Well, as much as we can talk about them. So while the IDEA isn't very specific about the timelines other than the 60-day timeline Dina spoke about, the California Education Code specifically states the timelines within which districts must follow and develop plans and then conduct the assessments. So the statute is very clear that an assessment plan must be developed and provided to the parent in writing within 15 calendar days of receipt of the parent's request for assessment. The 15 days don't include, though, any days between the terms, between semesters or the summer, or any school vacation days in excess of 5 days. So these are the timelines that everybody follows. There's been no issue unless the district doesn't comply, but this is how it moves forward. And then COVID hit, and the governor, on March 17th, Governor Newsom signed Senate Bill 117 into effect, which really brought assessments essentially to a screeching halt. That bill gave the districts an out by saying that the days that schools are closed due to COVID-19 count as days between the regular session, which meant that you couldn't get to that 15-day time period. So then no plan was being provided to parents, and no consent was being obtained, and no assessments were happening or that continues now. None are happening. The bill waived timelines also with respect to when districts are to produce records. So they are supposed to produce records within 5 business days of receipt of the parent's request. And that bill basically said, districts, you don't have to worry about that. Don't comply with that timeline. Do your best to do it as soon as you can, but there was really no impetus for them to do anything. So the districts relied on these timelines, on this bill and the waiver of the timelines provided in that, as well as the provisions in the county and state public health orders to essentially avoid assessments of any sort. So not only did they avoid assessments and have they not been completing assessments that they're required to complete by either their own psychologist doing the psychoeducational assessment or the speech and language, occupational therapy, physical therapy assessments, but they've also essentially put a halt to what we call independent educational evaluations otherwise known as IEEs, which are assessments that can be obtained when you disagree with what the district's assessment shows. You can request that the district fund an independent assessment, and those have come to a halt as well. So the district has told the providers, even if contracts were already in place, I had one case that literally they were about to get started and closures happened, and the district just put a complete stop to all of them and is telling the providers they're not going to fund the assessments if they go forward, relying on these county orders that are saying you can't have this in-person contact. So at least one district, LA Unified, is continuing to fund these independent assessments. And it's doing so even though there's evidence that the assessments can be completed safely, either in person or remotely. And with respect to the remote assessments, at least one of the psychologists with whom we've spoken has let us know that the correlation between the results of doing the test remotely and doing the test in person, there's a 95% correlation rate. So it's clear that the districts are really using this as an excuse, at least in my opinion, to not move forward with their obligations. The good news about this bill, if there's a good news, is that the timeline waiver included in the language expired on July 1st, 2020. So conceivably, that restriction is no longer in effect. The districts stopped assessing in addition to that statute, despite the fact that, as Dina said, the federal laws remain in effect. Now there is a new bill pending, 820, Senate Bill 820, which we thought, it's a budget bill, and we thought there was going to be language snuck in to try to put that waiver of the timelines back in so districts would have another out. But it looks like we've just learned that that is not actually going to be the case. So it looks like at this point, other than the county health orders, districts really don't have an argument to say that they can't, that they're not obligated to conduct these assessments. But the county public health orders do come into play. Each county is determining when, they have to meet the 14-day timeline to start integrating back into schools or to start opening schools, and that's on a county by county basis. Well, it appears that when assessments are starting are also going to be on a county by county basis. So Ventura County, for example, was just given clearance to start assessments. I haven't seen any actually starting, but we understand that the county, based on the recommendation of the county health officer, that he has given the go-ahead for assessments to begin. Los Angeles County has not yet, to our knowledge, authorized assessments to continue, and LA Unified, one of the biggest district in this county, has continues to hide behind that public health order to avoid meeting its assessment obligations. So in addition, the Los Angeles County Department of Public Health did issue a revised order a couple of weeks ago on August 12th and confirmed that the services related to mental or behavioral health are still available, and that home-based care for the disabled is considered an essential business, which is permitted to operate during the COVID closures. So I think maybe arguments can be made that assessments related to these areas of need would be deemed essential and potentially can move forward despite these other restrictions. Additionally, just 2 days ago, the California Department of Public Health issued new guidelines which state that as kids move back into school in these small cohorts, one-to-one specialized services may be provided to a child in a small cohort, and they divide those specialized services include occupational therapy, speech therapy, and other medical, behavioral, or educational support services. So it makes me wonder, are those only going to be provided for kids who have services in their existing IEPs? It seems as though that would also potentially give grounds, arguably, to have assessments moving forward so those services and needs can be identified and the services provided per this order. I don't know whether this order is going to override the local county orders that are still in some counties prohibiting one-to-one service. So that is something we're going to have to see how that plays out. Lastly, the Office of Special Education Programs within the U.S. Office of Education has also issued a guidance letter, and I believe Brian's going to speak about that in more detail later. But that letter also encourages districts to explore whether assessments can be administered remotely. So it seems as though there are opportunities out there, and we are going to have to figure out what we can do to get districts to move off of this hiding behind these county orders to start getting some of these assessments done. But where does this leave us? This leaves us now, because the statute providing the timeline waiver expired on July 1st, with what seems to be a lack of compliance with assessments. We still have a federal law that hasn't changed. Districts are still obligated to comply with the IDEA. Many of the IEPs that were convened during the spring closures were done without those pending assessments being completed, which I think will raise questions as to the accuracy of the present levels of performance and the appropriateness of the goals of those IEPs. There are several private educational psychologists who are conducting assessments in person in a safe and socially distanced manner, or are willing to conduct assessments remotely. So if the districts continue to refuse to fulfill their obligations to assess, and a family is in a position to do so, one option may be to give notice to the district that you intend to obtain a private assessment because the district is refusing to do so, and that you are going to fund that assessment and seek reimbursement from the district. And then at least you'll have a document with updated assessment results that you can present to an IEP team and potentially move forward. And then we're also going to discuss a little later other potential actions that can be taken. I think Valerie's going to touch on that a little bit later. And right now, Sophia will start to talk to you about some of the issues, state issues affecting IEPs.
Hi, everyone. Thank you for attending. I'm Sophia Bliziotis. I've worked here at Newman Aronson Vanneman for about 15 years and cannot imagine practicing in any other area of law. Next slide, please. I'm here to talk to you a little bit about SB 98, which I conceive of as the roadmap to distance learning. It amended and added sections to account for the situation we find ourselves in. And many of you, from what I hear from all of my clients, experienced the chaos that was the transition to distance learning abruptly in the middle of March. I also hear it from teachers and administrators as well, just tearing their hair out. And what SB 98 is supposed to do is provide a degree of flexibility and creativity to implementing distance learning. And we've been told that it will provide a more robust program of distance learning. It's not the feedback we're hearing right now, that it in fact is living up to its promise, but we're hopeful, sort of. Different counties are going to be doing it differently. Right now in LA County, there's no hybrid instruction going on between distance learning and small pods. There are some smaller districts that have, for daycare purposes and under a waiver there, having small pods that are very strictly regulated. But that's not what's happening in LA County for the most part. So that was the intent behind SB 98. What they did was add requirements and honored the fact that the IEP still has to be implemented. That's the idea behind it. Next slide, please.
So some of the sections that were added were, they defined distance learning in a very common sense way, which is you have pupils and you have teachers and they're in different locations. They had to put in a section that allowed for distance learning, and they did that. But it's only under two circumstances. There's some sort of order or guidance from a state or local public health official, or there's a student who is medically fragile and would be put at risk if they had to return to school, or the student, for any number of reasons, needs to self-quarantine. So that is, those are the circumstances. There's still a very strong preference in the law, even with the add-ons, that in-person instruction should be provided to the greatest extent possible. And I'll talk about this in a moment or two, but attendance, which is actually participation and engagement, is still mandatory, and it's something to keep in mind when you want to run screening from the room. So you can look at, we have a link to the California Department of Public Health that was referenced earlier by Jody about the small pods. Next slide. So the good news is, particularly if it's enforced, is that distance learning has fairly rigorous or strict requirements. First and foremost is that districts or the local county office of education, or the charters, depending on the entity in charge, need to provide not only the devices, but the connectivity. And that's of great import, obviously, because there's no way to engage in the learning or to do the homework, complete assigned work, because one can imagine, the connectivity being from whatever the hours are, and then it being cut off, and that's not the case. The content still has to be aligned to grade level standards, and the idea behind SB 98 is that the same level of quality of instruction, good, bad, or in between, but it's the same level of quality of intellectual challenge as well, should be in person to equivalent to in-person instruction. So they're setting the bar relatively high, in the sense that, particularly in spring, we had a lot of parents saying, I can't believe what my child is being taught. It's below their level. They could be doing more if they were, engaging in learning games online. So again, we've been promised that it'll be more robust with some of these protections, or at the very least, give you a basis to complain, either through legal means or other means. Your child's IEP, and including the related services and any other services that are needed, are supposed to be delivered during this time of using distance learning. This also is true for English language development. And probably the most interesting piece of the requirements, in contrast to what happened for a lot of students during spring, is that there have to be daily live interactions with certificated employees and daily live interaction with peers for purposes of instruction. But interestingly enough, they really acknowledged the idea of school connectedness having to be maintained, because the disengagement risk is incredibly high. And they also have to have the daily interactions to monitor progress, so which I'm going to talk about in a moment. Next, thank you. So I want to go back to attendance. It's being called in SB 98 participation. and engagement. So when Dina, I think it was talking about the documentation piece, this is critical. I mean, it's almost like you're a behaviorist. You're just taking notes. Like my child was able to pay attention for 15 minutes and then stopped, walked away, did whatever. It's just like a daily log of what's going on. So they have to show the district, county, Office of Education, charters, the entity in charge, they have to demonstrate that there was participation in online activities, in the assignments, and in the school assessments, not assessment in the way that Jody was talking about it. They also, there has to be contact between the school and the pupil and the parent and or guardian. They need to be in communication with you. So again, documentation, a quick sort of school log diary would be important. Students can still be marked absent. Some of you have had the experience of students with school refusal and then being threatened with a school attendance review board action. It's important to keep in mind that attendance is mandatory, or participation to some degree or another. So that's, again, another reason why the logs are important, to show what happened. So something that's really fascinating is the section where the entity in charge has to define how participation is going to be measured. It's not up to you. They have to assess students for learning loss. They have to have a plan to address student learning loss. They have to have a plan to measure the effectiveness of the interventions used to address learning loss. They have to have a plan to monitor, this was really interesting, the mental health and social and emotional well-being of both the students and the staff. I'm awfully curious what that's going to look like, what that plan to monitor is going to look like. And that's why it's also important for you to be in touch with the teacher, the AP, via email to say, you know, my child was showing this stressor, etc. It's a way of creating a paper trail of your child's experience. And they also are obligated to figure out what additional supports and accommodations are needed for special education students, English learners, students in foster care, and students who are experiencing homelessness. It's a tall order. But they are obligated. Could I have the next slide, please? No, there is no next slide. Brian Wynn, I did want to mention one last thing about, there are minimum instructional minutes that you should know about in SB 98. There's 180 minutes per day for kindergarten, 230 minutes per day for grades 1, 2, and 3. And there are 240 minutes for grades 4 through 12. Brian Wynn's going to talk to you now.
Hi, thank you, Sophia. So I'm Brian Wynn. I have been at Newman Aronson Vanneman for about 14 years, and it's gone by very quickly, but we've done a lot of good work here that I'm very proud of. So I'm going to talk to you a little bit about due process and what remains in effect. And essentially, due process represents the rights you have against an entity, a state entity, and the obligations they have towards you. Recently, the Office of Special Education, U.S. Department of Education, and Rehabilitation Services issued a Q&A regarding federal law and guidance during COVID-19. That'll actually be attached to the materials, so you can take a look at that more in depth. But one section I'm going to focus on here is IDEA Part C, which represents a 45-day timeline, which is also in the regulations as well. The 45-day timeline that I'm discussing applies to any screening offered by the state, the initial evaluation of your child, the initial child and family assessment, and the initial individualized IFSP meeting. Next slide, please. So what are the exceptions available to state lead agencies and its early intervention service providers in meeting the 45-day requirement? Now, obviously with COVID, there has to be some flexibility at times to get certain things done, because obviously in-person assessments and things like that and evaluations are not going to be as accessible. So the usual requirements, absent something like a COVID or some other crisis, would be the child or parent is unavailable to complete the screening, initial evaluation, initial assessments of the child and family, or initial IFSP meeting due to exceptional family circumstances documented in the child's early intervention records, or the parent has not provided consent for the screening, initial evaluation, or initial assessment of the child, despite documented repeated attempts by the state LA or EIS provider to obtain parental consent. So in those situations, it's really the parent, or there's some other obstacle for the parents consenting to such assessments. Those would be the usual exceptions under the 45-day timeline, absent something like COVID. However, with COVID, hang on one moment. So under COVID, or any other national emergency, so say if we had a hurricane or something like that, which some of the country is facing right now, meeting the 45-day timeline may be difficult or impossible. Under this exceptional family circumstances outside the control of the state LA's or EIS provider's control, the state LA or EIS provider must, in these particular circumstances, document in the child's early intervention record or exceptional family circumstances, like what's happening and why they can't meet the 45-day timeline. And then as soon as possible, they need to complete the activities documented when the exceptional family circumstances no longer exist. I recently got a call from a client who was telling me that the district was actually being pretty creative with assessing their child, doing an evaluation. I think it was a speech evaluation. They had them outside on the school, in the lawn of the school, and they were outside and actually were able to get some data and then work through an evaluation. But they had been trying to get that assessment for quite some time. So that's something that I think there is some creativity going on, but it's rare. I think that for the most part, a lot of these evaluations are going to get delayed. Next slide, please. Can the state LAs and their local EIS providers use the interim IFSP until a face-to-face evaluation or meeting can be held? In these circumstances, yes, they can use the initial evaluation or the IFSP for interim IFSPs, where documented exceptional family circumstances delay the completion of the initial evaluation and assessments during the 45-day timeline. Next slide, please. Okay. The California Department of Education has also said that when obtaining consent for an IEP, it still has to be, there's been questions about whether it can be verbal and is that sufficient. It is not actually. The district still has to obtain, or the state LA has to still obtain consent via writing, and that can be done through DocuSign, Adobe Sign, etc., as well as scanned photographs of signed signature pages. And that applies to, I mean, we need to have written documentation of everything. So if somebody tells you, you know, verbal consent is okay, that's certainly not the case. Make sure you get everything in writing. I know that a lot of the procedures that we're doing in terms of the IEPs and things like that feel very relaxed right now, but still at the end of the day, you need to make sure you have that IEP sent to you in writing, and you need to make sure you sign it and send it back to them as soon as you can with your concerns. Next slide, please. Okay, I guess we're moving on to remote learning challenges. I think I'm sending this off to,
To me,
Jody.
Brian.
Okay.
I'm back.
Sorry.
Actually, Jody and I are going to talk a little bit about this, and we've actually, talked around it and mentioned most of it already, but some interesting things that have happened in the last couple of days. Something that Sophia said is the technology requirement is very interesting. Parents need, in order for a child to access their education, they need to have the technology to do that. They need to have good internet access, and they need to have good devices. And it's the school district's responsibility to provide that if the parents can't afford it. And one thing that happened I don't remember how long ago it was the governor the mayor said they were getting together a bunch of school buses and setting up remote internet access in areas where there was spotty internet access so that families could access the internet better and their kids could participate. And I thought that was genius. I thought that was really great. In terms of, I'm sorry, we had three different things here. Okay, so access to internet is important. One-on-one services, in-home services is something, excuse me, that I wanted to talk about because so many of our clients have said to us, my son has a one-to-one aide, but the district's not letting the aide go into the home to assist my child when my child's in the virtual program, and therefore my child's not able to access the program. And this is happening very frequently. And most of the districts are saying no, because they're saying we're not going to allow our people to go into homes and provide the one-on-one service. And so some other options that parents have been looking at, and I've heard a couple of different things, but the regional centers, sometimes if the child doesn't have any other means of providing one-to-one support and needs it, the regional centers sometimes will, for a temporary time period, add to the number of respite hours or daycare hours that the family has to help with, to help with the online learning. The other possibility is insurance. Some insurance companies are willing to provide or extend the time periods for in-home support services for behavior. And then the thing to keep in mind is that the governor's executive order, and it is somewhere in here, hold on a second, I don't know what slide we're at, but it will be in the slide. There you go. Sorry. The governor's executive order, N3320, provides that, talks about who are deemed essential workers, and behavior support people are deemed essential workers, and so can provide services in home. Also, people like nursing services. For example, I have a client whose child is continuing to get nursing services in home because they need that in order to access any kind of education. My son, for example, is continuing to get daycare and nursing services in home because they're deemed to be essential workers. And it really depends on the family as to whether or not you're willing to let somebody come into the home, and what kind of requirements you have. For example, are you going to require a mask, the person wear a mask? Are you going to require that they keep a social distance? We've set up a table that has masks, hand sanitizer, gloves, and paper towels. And so right in my front door, whenever anybody comes in, they do all of that. And every time they walk out, they come back in, they sanitize. So, and we're all getting really good at carrying hand sanitizer around. One of the things that we've been seeing with LA Unified is they've strictly prohibited any support people from going into the home, any behaviorists, any nursing, any DIS providers. So I don't know what's going to happen with that, but there's something interesting that Jody's going to talk about, and with regard to that just came down. And so there's going to be some changes, and I'm going to hand it off to Jody to talk about that.
So one of the other concerns, just like the one-to-one aids, are the related or DIS services. How is speech therapy, occupational therapy, physical therapy being provided via Zoom? Obviously, many of these services require in-person instruction. And instead, instructions being provided by a check-in or an instruction sheet, and the parents being required to become the therapist in essence while they're, juggling work, juggling their other children's distance learning. And obviously, it's not in a workable situation. And there are some services, and I've heard of some families that the Zoom service is fine. You can do some fine motor work via Zoom. You can have some language discussions. But some of the others are just more intense. And this is, again, where it just seems the districts are failing. I mean, obviously, this was an unanticipated situation we're in, but they're failing with respect to the provision of these services, again, in my opinion. But here's where I believe, again, it's really important to keep a log of what is being provided. I know I touched on this before. Dina mentioned Otter. We also have a sample log sheet on our website that you can access. But I believe it's—
And Jody,
yes.
if I could interrupt you, we just posted in chat how to access that on our website.
Oh, great. So in the chat is access to the log on our website. But I think it's really important to keep track of how many minutes your child's supposed to receive, say, of speech therapy per the IEP, and how much is actually being delivered. And then also keep notes on, are you seeing progress? Are you seeing regression? Are you seeing, just sort of maintenance and no real changes? Because those are what will drive an argument for compensatory services, as Dina was explaining earlier. So that's a really important factor in this area. As I mentioned earlier, the California Department of Public Health came out with a revised guideline 2 days ago, which is going to allow these specialized services be provided to a child in a small cohort at school, so that the guidelines were that there could be a cohort of no more than X number of kids with 1 or 2 designated teachers, and this guideline is allowing another provider to come in and work with that student. And again, those providers include occupational therapy, speech therapy, and other medical, behavioral, or educational support services. The one caveat with respect to this document is that it says it does not supersede other guidelines that are in place for these services. So I think there's still going to be some conflict with local counties, and we just need to get more orders from the local county public health departments that these services can be provided in person.
Could I just interrupt you?
Yes.
Jody, could I interrupt again for one moment? Someone has posted in the question and answer that they have followed up with the Los Angeles County Office of Education with regard to that guideline that came out on Tuesday, and at least as of this moment, the position of the Los Angeles County Office of Education is they're not going to be following the State Department of Public Health guidelines because we don't have county health guidelines yet that allow that to happen. So that continues to be the issue of these things change day to day, but that's where we are in Los Angeles County at the moment.
And the last topic we wanted to touch on with respect to distance learning are the student challenges. So, you see it posted on all different social media platforms. If I could actually see all of you, I would be asking how many of you are actually seeing your children just having an incredible difficult time with either the stress of distance learning or the inability to maintain attention during distance learning, or feeling anxious being on screen, or having to raise their hand and the Zoom comes in on them and they feel like they're on the spot. So what we're hearing about are kids who are really reacting or having a difficult time adjusting to this mode of instruction and really causing significant stress for them. So, some things that could be put in place are accommodations, just as if they were in a classroom. And you could try to do that either by speaking to the teacher directly, seeing if they're willing to informally do it, or call for an IEP meeting and ask that additional accommodations be put in place. Maybe the student can check in with the teacher can see the child, and then the camera can be turned off. Perhaps additional one-to-one time can be worked out between the student and the teacher for some time after or outside of the Zoom hours. Maybe breaks can be written in so that the child gets up for a few minutes, it's not held against him or her. I think we really have to be creative, but I think you look at whatever accommodations your child might need, whatever comes to mind to you, as something, you treat it the same as something you would as a classroom accommodation right now. So those are just a few thoughts that we had as far as challenges with distance learning. And now I'm going to hand the floor back to Valerie, who is going to talk about next steps and courses of action.
So here we are with the 60 and some plus questions, all of which are valid, all of which are important, and all of which go to indicate that distance learning, except for a small number of high-functioning students who would prefer not to have to engage in social interaction, are not working so well. What can we do? What are some of the things we can do? There's a couple of things I want to talk about and then go in and try myself, and with the help of the other attorneys here, talk about some of the rest of it. And in addition, I want to alert Sonia, our great interpreter who's with us, that there are some questions in Spanish in the question and answer, and I will be throwing a couple of those to you. So let's talk about first what we can do. Is the slide able to be shown? I understand we had a slide link go down at some point. Okay. First, we've said this over and over, document everything. I think you've now heard it enough that it must be coming out of your ears. It's a little bit like the IEP meeting where the school psychologist keeps saying to you, but that's what we said before. And so we're not going to say it again, except do keep track of everything. And we've given you some thoughts about things to keep track of, including things that you would not normally keep track of. And one of the things I want to talk about is the one you see at the top right of the slide, baseline data. We've not been very good as a community really enforcing the need for baseline data, or not all of us have been very good about it. Baseline data is essential. If it means you have to spend a day with your child counting the number of words the child uses or the number of times they're able to watch the Zoom, or getting baseline data, take a little bit of time if you have it and get that data. Because otherwise, what will happen down the road is we get into litigation over all these issues, and a lot of them are going to end up in due process and litigation, is we won't have that information. And that information is absolutely essential. So if you have the ability to do it, you have the time to do it, or if you have some providers who are providing private services who can do it, part of this document everything includes trying to document some baseline data. Let's go to the next things that we need to talk about doing if we can. Due process. We just talked about due process timeframes remain in place. I will tell you that as a result of the pandemic, the increase in the number of cases that are not being resolved at mediation and that are going to hearing has increased 100%. I spent the last 5 to 7 years resolving 100% of cases in mediation prior to the time of going to hearing. I have been in 4 due process hearings since the pandemic began. For me, that's a 400% increase, and it is not going to stop. Districts are wanting somebody else to tell them what to do. That means we as attorneys and you as parents and advocates need to be keeping extremely good records so all of the information we need as we go down this road are in place. The second part of this, in terms of having somebody else tell them what to do, has to do with stay put. Some of you have had me give you the stay put lecture in various contexts over the last 40 years, and you're tired of hearing it, but let me review it for you real quickly. When the law was passed originally, we were desperately afraid that what would happen is we would have Johnny in a very good program, and the district would kind of come along and want to move Johnny out of that very good program and would say that they could do so while we were fighting through due process and going to court. So written into the law from the beginning, from the time the statute was passed in 1974, is a provision that has become known as the stay put provision. And what that stay put provision means is that you are entitled to the last agreed to services if there's disagreement about your services. In a case decided this week, earlier in the week, by the Office of Administrative Hearings in a district up north, a small district up north in a small county, with a child who had incredible needs. I mean, incredible needs. This is a child who had an IEP with an LVN written into the IEP that specifically identified 14 different tasks that the LVN was to perform during the day. In that case, based upon the public health order in effect in that county, that particular county, and the stay put provisions of the law, the Office of Administrative Hearings found that stay put required that they send the essential workers, and in that case they were the LVN, they were the OT and the PT, the speech and language person, to the student's home. Does that mean we can get it in every case? For those of you who are sitting there with IEPs that have those services written in, the answer is probably not. You're going to have coming together that unique combination of things that will be able to have the argument made as to stay put. It is, however, a breakthrough, and it does indicate that we're beginning to see a way through some of this to begin to put some pressure on. Now, in order to get stay put, you have to have filed for due process. You have to have filed a due process complaint that says what the district is doing is not meeting my child's needs, and I'm entitled to stay put. I want to be clear with you. I think the case in which OAH issued the stay put order was incredibly unique, at least as the facts are reported in the decision. I think that OAH is going to ultimately probably pull back a little bit and may rely on health orders that aren't as extensive as the one in the county up north. And right now, the health order in Los Angeles County is relatively narrow. Even the LA County health order, however, does talk about some essential workers. And so it is possible that in the right case, with the right circumstances, it might be possible to begin to argue stay put. I do not want to give you false hopes about this. I do not think it's a panacea. I don't think every case is going to work for it. I don't think it's going to happen automatically, but we now know that, excuse me, we now know it's a possibility and it's there. I would turn to my other panel members to say if on this stay put question, they have any input they'd like to give. You'll have to unmute yourself if you do, however. Anybody? Okay, let's move on to the next question. The next slide. I think political action has now come. I think it's the time to do it. I don't think school boards, by and large, understand the inequity of services that's happening with regard to students with special needs. And I think, in fact, it's time to let them know. I think we've become a really quiet little minority, and we need to be able to get out there and let them know. Some suggestions are let them know of your concerns, schedule a meeting with the director of special ed, write letters and emails. I also think you need to be in constant communication and let your state legislators know that you care about special education. When the pandemic first hit, we got this stuff that Jody was speaking about, where we got the delay, sort of, nobody knew it happened. LA Unified's lobbyist apparently went up there and bang, bang, thank you, ma'am. all assessments were stayed. We need to keep a constant eye on that, and we need to let our representatives know. And then, of course, most importantly, we need to vote to make sure that people who are making the decisions are people who care about the community we serve. I want to try and answer and then ask folks to chime in, Dina, Jody, Sophia, and Brian, to chime in with some of the questions we've gotten and some of the answers. We're going to try and group them, if you would. And I'm grouping the first sets of questions, both the ones that came in prior to the webinar and have come in since. And I'm going to start with a question that deals with the following issue. The district is refusing to complete the assessment, even though I have an assessor who can do a remote assessment and who's willing to come in and have that assessment done personally. And I am willing to have them do it face-to-face. Can I go ahead and get that assessment done, pay for it privately, and then try and get the district to pay for it? I cannot tell you there is a case that a parent has prevailed on with regard to that, because none of them have happened yet. What I can tell you is it is, in my opinion, a viable legal argument, because I think the district has its head in the sand with regard to this assessment issue. Having said that, I think it is vital that if you plan to go that way, you make sure that you've given every conceivable type of notice that needs to be given. That you have in fact given notice that this is an assessment in which 90% of it was done. The only piece that needed to be finished was this little piece, and this little piece could be done. You have refused to do it. Because you have refused to do it, because the timelines are in effect, you've left me with no choice but to go get it done and to seek reimbursement from you. Can I guarantee you'll get reimbursed? Absolutely not. Could anybody guarantee that you would get reimbursed? In my opinion, absolutely not. But we've got a right under the law to it. We have at least the ability to see if we can make it work, and it is one option for these assessments. The other part of this is, the districts, in my opinion, like to do assessments so they'll have people down the road to testify against you if you make a stink, and they can come to hearings saying they've seen your child. Well, that's just not a valid reason for refusing to do something without an assessment. If you can show that there's enough collected data together from whatever source that it would allow an IEP team to determine that a service ought to be given, you still have the right, and this one they can't get away with. You have a right to an IEP within 30 days of the day you request it. That law, because of what's happening in the trailer bill, is not stayed. That law, I would be using that law to ask for an IEP, to get into that IEP and say, you've got this information, we need this service. If they're going to deny it, you can then say, I'm going to have to go out and buy it, or I'm going to have to do something else to get it, and you're going to have to pay for it. But do remember that they cannot avoid holding an IEP. If they do not hold an IEP within the 30 days that you ask for it, there are all sorts of other issues that then arise, excuse me, as to what you might be entitled to down the road. Do any of you want to chime in with regard to this assessment analysis, Dina?
I do. I think something that's really important that's come up in a few of my cases is that the observation of the child in school piece on outside assessments and on assessments by the school districts. And I've had situations where independent assessors are willing to actually go in the home and observe the child in a virtual school setting, and the districts have refused to allow that. So, and that is a piece of the assessment, observing the child in school, that's going to be important. I'm not sure, Valerie, do you have a way around that, or do you have any suggestions on that?
Not any that I haven't already made.
Okay.
Anybody else from the panel? Anybody else have any thoughts, Brian? Anybody?
No, I'm
Sophia?
just going to add to the chorus of things like an FBA functional behavior analysis assessment, getting the award in a settlement agreement for an independent one. And, the argument could be that there's even a greater need for an FBA because the student has behaviors around distance learning. The arguments are there. What will happen is what Valerie said. We have no idea.
I've been doing this, you can tell by the wrinkles on my face, all of which have been caused by Los Angeles Unified, not by age, that I've been doing this a very long time. I don't think, other than the first 2 years after the law was passed, from about 74 to 76, I don't think I've ever had to say, I do not know, as many times as I've said, I do not know since March. We are in a new world and a new time, and we don't know. We don't know. We can guess, we can speculate, we can use our knowledge, background, training, and experience to give you the best answers we can give you, but there are a number of unknowns, not the least of which is that we do not yet have, other than this single stay put order, any indication from the Office of Administrative Hearings as to what it's going to do on compensatory services. The next block of questions we've had, and we've got this question has come up in a variety of ways, and I'm going to try and take it, and I think if I'm reading Spanish in my own little way as well as I can, I think it's come up both in English and Spanish questions, is the following. They're killing my kid with this Zoom stuff. My child can't benefit from it. It's making him worse, not better. They're just making him crazy. There's no benefit coming from it. Can I simply say stop? And what's the repercussions from simply saying stop? Comes up in a variety of contexts. It comes up with regard to the educational program itself, and then it comes up with regard to the related services. I want to talk first about the educational program and give you my thoughts on it, and then ask Jody and Dina to maybe chime in, and Sophia and Brian with regard to what they may think about it. As with all things, I think you need to be able to show that you've documented it. So, for example, you have a child who is supposed to be in a general education class, but in order to be there requires the assistance of a one-to-one aide. The district has that one-to-one aide sitting off in a corner somewhere doing goodness knows what, while the general education teacher is there and there's some limited kind of interaction that may be taking place, and your child's going a little bit frustrated and crazy. In that situation, once you've tried it, and I know some of you find it very difficult to try because it's painful to watch your children suffer. But once you have tried it so that you can say, no, we did try it. And here's what happens to my child. You document that. And you say to them two things. One, I'm happy to go to an immediate IEP meeting to discuss effective distance learning for my child. Don't ever not say that, in my opinion. If you're going to say this distance learning is not effective for my child, also say, I'm prepared to come to an IEP to talk about what effective distance learning will look like for my child. As Sophia said, there's all sorts of requirements now that they're supposed to put into that distance learning. Secondly, while they mess around trying to decide how they're going to respond to your request for an IEP, if in fact it's just not working, it seems to me, and I'd be interested in, and Dina, Brian, Sophia, and Jody and I have not discussed this question among us. I'm bumping it on them at the last minute. They love it when I do that. But it seems to me, just as in any IEP under California law, we can accept certain services and decline other services. we ought to be able to say, we are accepting having you send me the curriculum home. We are accepting having you keep me informed as to what's going on in the classroom. We are accepting this, this, and this. We are not accepting the part of it which requires my son to be on a Zoom call for 3 hours a day because he can't do that. That, under the statute, I think may work. Under the theory that we can accept part of the IEP and reject part of the IEP, it is at least worth a shot, and it provides color. I would be interested in what any of my other panelists think about that.
Raises a question, not to play devil's advocate here, but does raise a question to me. If you do that, which I think is a great idea, then the default placement becomes the stay put placement, which was in school, presumably. And so then how do we mesh those two pieces?
And that's the second part of my wild plan. I've lost you all, right? Has everybody else lost everybody? Or just me? And that's the second part. I think as we give notice that we're accepting parts and not accepting parts, as to the part we're not accepting, we say, and either we're going to go out and buy some private services for that part because you can't do it, and we're putting you on notice that we're going to get compensatory services for this. One of the questions that came up, and several of you who posted questions, is, are we really ever going to get all these compensatory services? We know there are some 80,000 kids in Los Angeles Unified, for example, alone, who between March and June got very few, if any, services. What's going to happen if all 80,000 of those kids who got no OT, no speech, no PT, no adaptive PE, no recreational therapy, no counseling services during those 3 months all filed for due process at the same time? What do you suppose the outcome would be? I have fantasies sometimes late at night about such a thing, because obviously that's what could happen. And indeed, I do think that there are going to be valid claims that can be made for the lack of services, probably not from March 19th. My best guess is OAH is going to say they probably had a couple of weeks to try and get stuff together. But certainly as of the time between the spring break, when the normal spring break would have been in the end of the year, there seem to be some valid claims that can be raised in that area. Similarly, as to the programs that are not working now, we document them. We say we need a distance learning IEP. We're going to take these and not these. Push it in terms of it. This is an opportunity for parents and providers to be incredibly creative. There is stuff that I think we probably haven't even begun to think about that can work to provide perhaps even better educational services than we had before. Jody's correct. They're going to say, well, Stay Put was a regular program. You get nothing if you route out of that regular program. But remember what Sophia said. Remember what Jody said. The law now says we're entitled to comparable services. We are entitled beyond that to services that are equal to that being provided for non-disabled students. So as this year begins to swell, and as it looks like in some areas we're going to have more of this at-home business, I think we need to be able to think about using the law in very creative ways. And that's one way to do it. Yes, Tina.
If I can jump in, one thing I think is going to be crucial is to absolutely go to an IEP meeting. And if they're not scheduling an IEP meeting, document that. But you need to request an IEP meeting if you're going to do any of this and not just say, okay, I'm done. Because that's not going to help if we have to go forward and get compensatory services. You need to follow the rules and try the best you can.
To that point, something that I forgot to mention is that new IEPs, initial IEPs, and annual IEPs, if this is still going on, this being COVID, have to put in a plan for distance learning. So joining in on Jody, Valerie, and Dina and what they said, ask for an IEP. I would recommend that everyone put in their written notice for an IEP right now to say, we want a distance learning plan. Please hold an IEP. And they have 30 days to do it. See what they come up with. They have areas that they are responsible for. I mean, what other, I mean, in one of the slides, I think it was the very last one, about what they have to, what they, meaning the entities in charge, the LEAs, the districts, charters, etc., is they have to measure learning loss, and they have to have a plan to address it. And they have to be monitoring your child's well-being. How they're going to do that, we don't know, but I would use those as talking points. What additional accommodations do you need for your child to be able to engage in distance learning? What other related services do they need in order to engage and receive benefit from distance learning? So, I mean, they're going to be overwhelmed with IEPs, but I don't see any other mechanism other than that to get it in.
And they can either be overwhelmed with IEPs or overwhelmed with due process filings.
Or both.
And because that's what they're sort of waiting for, I think. And it's a problem. I'm going to, Sonia, there is a question in the question and answer from a Miss Estrada. Are you able to get to that one? It has to deal with North Los Angeles County Regional Center, a topic I love to answer questions about. Came in at 8:05.
Before Sonia takes care of that, Valerie, 504 meetings. We forgot to mention asking for meetings for 504 students as well, not just IEPs.
Can you find it, Sonia?
Does she know we
It's from
can't?
Giselda Estrada. I think the question, could I try and answer it? Sonia, or will I interfere with what you're doing? Ah. Oh, in chat? Okay. I don't see it. I can't. I can hear you, yes. I want to speak about this in terms of this issue with regional centers. Regional centers are very angry at school districts. Even some good people in regional centers I have spoken to say, why are the school districts putting all of this onto us? Well, they're putting it all on them because they're payer of last resort. If you are a regional center client And as I said to somebody at the regional center, hey, you want to pay me to sue? I'm happy to take 3 months and do nothing but work on a big lawsuit for you. They weren't anxious to do that. So under the regional center system, if you ask for a service, they can't simply send you a letter saying, oh, it's not our responsibility, it's the district. You ask for a specific service, they have to send you a notice of action denying the service. The reality of the situation is the Department of Developmental Services has directed that regional centers be responsive to families in need during COVID. They aren't sending out formal notices of action because they never did. They don't ever deny their services properly. You have the right to ask to have them denied, and then you can file for what's called a fair hearing against a regional center. And if you have the ability to go into the mediation yourself with them, I think you will begin to find that some regional centers are a little more afraid of DDS than they may be of just giving the service, and you may be able to begin to get the service. The next set of questions that have come up is a waiver question. And I want to talk about this for a minute. We want to talk about it just for a minute. Can a school district come to you and give you a piece of paper that says, waive all these protections you have because we're having COVID? The answer is no. They really cannot do that. There are families and there are districts that are entering into waiver agreements so that a provider can come into the home. At the end of the day, what a place like a large school district is afraid of is somebody's going to catch COVID and then they're going to be sued for it. And that's what they're afraid of. So in those situations, there are times when people are in fact signing waivers because it's a narrow waiver simply saying, I'm giving permission for X service to be in my home and I'm not going to sue you should my child or I catch COVID. Those kinds of waivers are waivers that you might consider in particular kinds of situations. A blanket waiver, particularly a waiver that says, I waive my right to an assessment until school reopens, should not at this point, given the recent change in the law, be one that we would advise signing, except that, of course, for every case, there's that other little case where we might recommend signing it. But as a blanket matter, it is not a kind of waiver you need to sign. Look at what's being sent home to you. In line with that, there were questions about apparently there are some districts, and I'd like Sophia, Brian, Jody, and Dina to weigh in on this. There are some districts who are sitting in their little district offices without any parent input, drafting what they're calling transition or distancing IEPs, sending it home to the family and asking them to sign it. And apparently are representing that that's being done because it's a way to get your child these distant services. Any of you have a response to such a document or how you would respond to it?
My initial thought is there's a lack of parental participation in the development of the child's plan, which would be a huge, red flag and big issue for families right off the bat. Additionally, I mean, if the IEPs already provide for services, there shouldn't really be necessarily a shift in service. They should be implementing the IEP to the extent they can through the distance learning program. So that to me is problematic all the way around.
Anybody else? Dina, Sophia, Brian, any other thoughts?
My impression is, well, I guess the way I look at this is, in terms of the program being offered. I mean, if we could say the default is now distance learning as opposed to a general education setting, then we treat it like that. And that's basically where we start from. And whatever accommodations are necessary within that environment should be appropriately given. And if they can do that within the current IEP, and like Jody said, to the extent possible, why do we need a whole separate IEP to do that? We just change the existing one to accommodate within that environment, whether it be general education or SDC or what have you. So yeah, I agree with Jody's perception of that as well, that if the parent didn't participate, then I think that's a completely useless document.
I agree. One of my cases, the client keeps getting sent home. Oh, here's your new distance learning plan. Oh, no, we changed it. Here's another new distance learning plan. Please sign, please sign. You know, my client's going, what is this?
And I think in that situation where you're being sent distance learning plans that change the IEP, the response really should be is, I am happy to come to an IEP to discuss an IEP that would be in place during distance learning. And I would like to, in fact, request that. One of the questions that came up is, it's 30 days, calendar days, or 30 school days? It is 30 calendar days from the time you make the request. Remember in that regard, everything, and this has never been more important, absolutely everything should be in writing. Now, the question is, what does that mean in the age of COVID? We can't send return receipt registered letters anymore. One, because it's not clear the postal system is functioning. But two, there's nobody at the schools often to sign the green card. You still can send registered letters, which will prove that you sent it. That can still be done. Secondly, almost every place now, almost every place, is in fact got email addresses. There are situations in which parents, and myself included, would rather just type into the email instead of putting it on letterhead and attaching it as a letter. It's easier, it's faster, it seems better. I would advise against doing that when it's a document that's giving specific notice. I would advise, and I don't know if my colleagues agree with this, but I would advise you make yourself up some letterhead, type in it on a letter, sign it, date it, make sure it has your child's name and birth date on it, and then send it as an attachment in the email. And I would advise, depending on where you are and what school district you are in, sending it to, if it's in a large district like Los Angeles Unified and you're in the elementary level, you have these folks called assistant principals who are in charge of special ed, most of whom LA Unified, in its infinite wisdom, decided to change in the middle of COVID. So most schools now have new assistant principals of special education. I would send it both to that individual and to the principal. And I have a further thought. I have probably never before said this in a public forum, and I've really ever said it in a private forum. I think all letters to Los Angeles Unified personnel regarding special education needs for your child should also now be copied to, if it's an LA Unified, to Anthony Aguilar, the Chief for Equity and Compliance for Los Angeles Unified at 333 South Beaudry Avenue, 17th and 18th floor, Los Angeles, California, 90017. I would also send a copy of it to your local board member. It is, we have been this silent, quiet group, and we have not benefited from being a silent, quiet group. And now it's time to, in fact, say, look, here's the situation, folks. This is not happening. This isn't working. And we can't any longer hide it under the hems of the special education principals in the schools, or the Bridges people at the middle school and high schools. In other districts, smaller districts, I would certainly be sending it to the director of special education as well as the superintendent. And I might even begin to copy it to the president of the Board of Education. I think people do not realize the extent to which those least able to care for themselves have taken the brunt of everything that's happened. I understand it's terrible for everybody. Believe me, I understand it. I was in Egypt when this broke out. I got back on my own because I happened to have enough crisp new $100 bills to get me back to the United States. So my life is pre-Egypt and post-Egypt. And I will tell you, post-Egypt, I have never, in 50 years of doing this work, seen special education get the rough deal that I feel it's getting now. And it's time to come together as a community and to be heard. It's time to come together and to say to people, wait, wait, special education matters, special education works. Don't, please don't think that you can take your costs that you're trying to cover in other places out of our special education programs. And one of the ways to begin to have people understand that folks aren't happy and that there's things to be being addressed is to by, in fact, beginning to let other people know what the complaints are and what's going on and what needs to be addressed. That's my soapbox for the night with regard to that topic. But as we begin to do this writing documents, if we're going to write, we might as well write to whole lots of people. Jody has responded with Anthony Aguilar's name, and someone else has said, yeah, and his response is, call our 213 helpline number. Keep those responses, stack them up to show how responsive they've been, and then send them off to your board member and say, do you know this is how they're managing special education within Los Angeles Unified? So I would encourage you, if you're going to start writing, to write. I would encourage you to write thoughtfully, write carefully, document. The next issue that has come up in a series of questions is...
Can I interrupt for one
Sure.
second on that topic
Please
of
do.
writing? And since we're all so dependent on email these days, one thing that I have been doing on notices and telling parents to do also is most of our email programs will allow you to send an email and get a read receipt and a received receipt or an opened receipt. So you will get notice when the email is actually opened and when it's been delivered. And I think those are important to keep as well.
The other question that has come up is the following, and this is a very significant, important question that I would begin by answering by saying, we are all only lawyers. Other than Sonia, the people you see on the screen are only lawyers. We are not educators. We're not psychologists. We're not speech and language pathologists. There are those out there in the field who will tell you that we often act above our pay grade and pretend that we are, but the reality is, at the end of the day, we are lawyers. Despite being lawyers, we know the following. Most of you tuned into this call tonight have learned more about your child and more about the educational challenges your child faces on a day-to-day basis than you ever did before. As my dearly departed mother-in-law, ex-mother-in-law used to say, every cloud has a silver lining. And for this one, the silver lining is you know more than you did when you started. You know more about what frustration looks like for your child. You know more about how much one-to-one it takes to teach how to add double-digit numbers. You know more about how much effort it takes to, in fact, get the child to organize materials. You know more about really what are the reading comprehension problems my child is having and what do they look like. You know a lot more. What you don't know is how to take baseline data, or at least you think you don't know how to take baseline data. I'd ask you to pause and think about that for a minute. Many of you have watched other professionals, quote unquote, take baseline data. If you're just starting out as a 3-year-old, you've watched it only for 3 years. If you're at the other end, you've watched it for 18, 19, or 20 years. You know how to take baseline data. You're smart people. At the end of the day, parents know more about their children than anybody else. Figure out what works for you that you can defend as this is actual data I took. When the attack comes as to that data, when they say, well, you're biased because you were the parent, be able to say, I was sitting back watching X, and I made check marks, or I did a dot, or I did however you've seen your old ABA providers or whomever do it, whatever system you used, so that you can say, this isn't my impression. Here, I got 100 pages of check marks that are valid as to the time I took them and what I had, and they're better than anything you ever produced, because they were actually done in a time frame where I started and a time frame when I ended.
Or video snippets.
Or video snippets, although I have some problems with those, but that's a different issue at a different time. We would urge you, or we can't answer all the questions. I know we haven't answered them all. I hope that we've answered enough to give you some notion of where we are. It is our plan to do the following, and we'd like you to keep in touch with us. We are continuing to send out a monthly newsletter. One should go out next week. I unfortunately am in the middle of an interesting hearing with my favorite school district. It's not clear that we'll totally get it together by the first of the month, but it will get out next week. We do put in updates on our website on a periodic basis. When something new comes in, like a new public health announcement or something, we put it up there. So please look there. We also are going to do future webinars. If you have a suggestion for us as a specific topic, what we did tonight was sort of an overview, a big overview. We're not thinking of doing 2-hour ones, we're thinking more of doing 1-hour ones that would both be able to be done this way and then be able to be accessed through another system where you could just see it live. If you have specific topics that you think we should address, please let us know. How do you let us know that? Well, that's an interesting question. But you can let us know through our website. You can let us know by writing to us and saying we would need this or that. We are going to try, we'll have another one in the next 3 weeks, which we'll look at and begin to look at a specific topic. We do appreciate that you tuned in tonight. I'm going to ask each of the panelists if they have some concluding words, and then we're going to be ending the meeting. I want to start with Jody, because at least on my screen, you're up there at the top.
Next. Really, my closing words are hang in there. It's a tough time for everybody. I know you're all struggling with, unless you're lucky enough to have teenagers at home who sit in their rooms all day and you really don't hear anything. You're all probably having a difficult time with what's going on with the distance learning, coupled with all of us being, sort of shuttered. So really just hang in there and document, and hopefully there will be a light at the end of the tunnel soon.
Dina?
One of the questions that I saw that we didn't get a chance to take a look at real quickly was the adult piece, the transition program where the kids are used to being out in the community and are no longer able to be out in the community. And yeah, the law applies to those programs as well. I mean, that was the question. What do we do? We need to be very creative with regard to that, and we need to access whatever services and supports we can. And I know it's extremely difficult. I know in my own experience, my son does not understand why he can't go to the movies or go bowling or do all the things he likes to do. And as Jody said, we are all frustrated. And I know from personal experience trying to juggle working and taking care of a child and making sure that there's food in the house and the dog gets picked up, and it's overwhelming. But do the best you can and breathe. Sometimes I'm told that wine helps, even though I don't drink it. So, and hopefully stay in touch with us.
Brian?
I hear from a lot of parents who are really frustrated, really having a hard time with the distance learning. And I always tell them, like anything else, this is trial and error, and you're going to have to find the thing that works for your particular situation, and don't feel like you have to force it to make it work, because if it doesn't work, you've got to find something that's going to work for you, and just keep trying that until you find what does work. And again, like everybody else said, just document everything, and just be safe out there, and hopefully we'll all find a way through this at the end of the day, and I think we will if we all stick together.
Sophia?
Well, I second everything everyone else said, especially the hang in there because it's tough. But I did notice a question that caught my attention about a parent asking, since they are acting as a teacher, can they request training? And there is parent training. And it really caught my attention. The answer is absolutely try and ask in writing.
This is our chance to be incredibly creative. That's the best idea I've heard tonight. Absolutely. What a beautiful, creative idea.
Yeah.
You guys have got it out there. You know, you're a community who works at this every day, who knows how to make it work. Keep coming up. That is a creative, wonderful idea. Thank you, Sophia, for picking that one up. Anything else? Sophia, I'm sorry I interrupted you again, but I was
Not
so
at
taken
all.
with what a great idea that was.
Oh, yeah, it is. Nope, nothing else. Thanks.
Thank you, Sonia.
Okay. And Sonia.
Thank you, Sonia.
Thank you.
We're, I think that someone will be ending this meeting. And I do want to extend our greatest thanks to Sonia, who has, she sort of, I think by accident, found her way one day to the 17th floor at Beaudry as an interpreter. And she's been there for clients and attorneys around the state, around Southern California ever since. And we couldn't make this all work without her. Thank you all very much. We're sorry if we didn't get all of your questions, but we will keep working at it. I did see a couple of requests on topics. One of them was on a talking about doing a special program for 2E. I think that's something we should explore and see if we can do an evening on that. If any of you out there have a suggestion as to someone who's an educator in that field who might be willing to join us on that, we'd love to hear about that. If any of you are educators in that field and would like to join us on that, we'd love to hear about that. And please do let us know about other topics. So we're going to sign off now. Thank you very much all for tuning in tonight instead of watching the other event that was taking place. Good night all.
Thank you. Good night.
Thank you.
Good night.